Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning and related topics before I invite you to leave a comment below and wait a year to do a Q&A video. Oops. Well, today we're here to fix that. So without further ado, let's answer your trust funding related questions. Foreign bank accounts, pay on death versus retitling accounts, and putting jewelry and other personal items in trusts. Hit the like button, subscribe, and let's dive in. The first question is regarding foreign bank accounts and how to put them in trust, since it was something I didn't really cover in our How to Fund a Trust video, which you should watch if you haven't. I think it's a pretty good one myself. Now, this commenter didn't quite clarify what they meant by foreign, out of state, or out of country. I presume out of state, but we can discuss both. Bank accounts from banks in other states are easy to address in that you title them in your California trust the same way you would with an account at your preferred bank in California. For example, a bank that only has branches in Nevada, yet you have a California trust since you live in California. The bank will likely need to see a copy of your trust, but you can have a Nevada bank account held in your California trust or vice versa. No problems. Bank accounts in foreign countries are a different story, however. While our California trust is effective in any other state, it only applies to the United States. If you have a bank account, or real property for that matter, in another country, then you need to speak to an estate planning attorney in that country to address it. Next, we have, what if you list beneficiaries on your brokerage and bank accounts? Do you still need to put them in trust? This is a great question because it means if you're asking, you're on the right track. No, the act of picking a beneficiary means the funds from the account in question become the property of that beneficiary when you pass away, thus bypassing probate and not being included in your personal estate or trust estate. One last thing to keep in mind is that you need to remember to update beneficiary designations if something happens to that designated person. If they predecease you and you didn't update that designation, then the funds have essentially nowhere to go. They remain in your estate, thus risking a potential probate if they are enough to trigger a probate in your state. As a best practice, you could set your trust as a contingent beneficiary. That way, if your primary beneficiary dies before you, the funds will go to your trust instead and not trigger a probate, essentially a safety net. Basically, make sure all funds have a place to go, either through beneficiary designations or by being held in trust. This brings us to the last question, so why wouldn't you put jewelry in trust? How would a beneficiary know inventory of personal items deemed to be split among beneficiaries as per the trust? Essentially, what about the personal items? How do we address those in our trust? You generally aren't going to specifically reference jewelry pieces in your trust unless they are very valuable or you want it made explicit from the start who you want to get your jewelry. The reason is twofold. Number one, in practice, jewelry generally isn't considered when it comes to totaling assets for probate unless it's of particularly high value. And number two, if you wanted to change what is to happen to the jewelry, as in it must be sold or given to a specific person, for example, then this sort of change requires an amendment to the trust, thus getting a lawyer involved and all the associated legal fees. Therefore, we typically recommend our clients not to discuss personal items in the trust itself and instead address it in a separate writing, what we call a letter of instruction. The trust will then reference such and indicate the terms of that writing are to be incorporated into the trust at the death of the trustors as if it was written there in the trust in the first place. The intent is primarily to allow people to take time to designate who is to receive what of their personal items and freely change their mind without having to go through the law firm to do so. Additionally, having a proper pour-over will ensures that all assets, including jewelry, held within one's estate at death are to be poured over into their trust at death. This means that one's jewelry would become part of their trust estate unless the jewelry is so valuable it would trigger a probate. However, if that were going to be the case, then it would be addressed when establishing the trust, well, in the first place. Check out our video on pour-over wills for more information. Lastly, keep in mind that probate thresholds vary greatly by state, so speak to an attorney in your state for your magic number. As a general rule, it seems that the further east you go in the US, the lower that number is, meaning you have less wiggle room to have before probate is required. Alright, that's enough questions for today, but we'll do it again real soon, I promise. I'm attorney Andrew Bethel. Drop a comment below if you have any questions. Don't forget to like and subscribe and check out our other great videos. Stay informed, and I'll see you next time.